Evening, everyone. Bear with me with the usual admin bits. So, uh, first thing to say, as we always do, guys, is this is a space to ask what if questions that are anonymized. So, no questions in the first person, if that makes sense. If you do put personal stuff in there, I'll politely remove it and ask you to rephrase it. And also, this ain't legal advice. We're going to do our best here to be useful, but obviously, there's some pretty obvious limitations in terms of trying to give accurate information when we have limited information to base it on. So we're going to do our best here, and I think there is going to be some stuff that is useful, but just kind of treat everything with a pinch of salt, basically. Um, so that's the usual bits. I think I've done. Oh, handset. Have I done that bit? I need to pin that thing there. Cool. Say hello if you're in the chat. Nice to see who's around. Yeah, I've had a long day today. How you up, Martin? Nice to have you, mate. I've got no news from this week, I don't think, although I've had such a long day, I wouldn't remember if I did have. Will, you said there was a case that was interesting. I don't know if you want to kind of speak briefly about that. Are you on mute?
Hello. Yes, I'm afraid I haven't had time to read the whole thing. I've read about 15 pages of it, which got me as far as the facts and the legal issues. The case is called AN and the London Borough of Dagenham, Barking and Dagenham, sorry. It's a judicial review, and I won't go through the whole thing because I haven't had a chance yet. But it concerns a very set of facts that will be familiar to most people. So, a woman with a single mother with a daughter with special needs, who has a sort of special support at school, applies to a local authority for accommodation. They tell her basically, well, Barking Dagenham say you're not working. The rent in Barking Dagenham's too high for you, so you're going to have to accept somewhere else outside the borough. But the issue, I haven't got as far as seeing how that argument went. Now, she won on most of it, but the case is really good because it deals with a number of overlapping issues. I mean, also they put her in bed and breakfast for more than 6 weeks, so they got in trouble for that. But there's, if you want to know about, I mean, Mike and I often, well, we all talk about that case, the Lambeth one, where they put the family in down where the docks were, down the
Gravesend,
Thames. Yes,
YRV Lambeth, yeah.
yes. So this is similar in that it deals with so the issue of Section 189A assessment. So they've got to do a proper assessment of housing need. It also deals with personal housing plans and the distinction between the two. So you have to have a housing needs assessment report and a personal housing plan based on that. And there's been a lot of cases recently saying, well, you don't really have to do an assessment. If it's on the file, you can sort of piece it together. And then there was a case recently saying it is possible to it's possible to make a suitable offer without having carried out an assessment. So it's not absolutely essential to carry out an assessment, but that's been interpreted wrongly to say that housing needs assessments aren't necessary, because you could make somebody a suitable offer and just by good luck everyone's happy, but it's when you get it wrong that you need the assessment. So this one also deals with, because there's a child with special needs, it deals with the Children Act 2004, the duty to promote the welfare of children, and also the public sector equality duty. So that these are all things that factor into the decision making when considering suitability. So it's a really good case. And the one of the good things about reading judgments as a way to understand the law is that you're getting, in this case, as a judge, I mean, most people are probably too young to remember there used to be a famous actor called Alan Bates. But this is a judge called Alan Bates who has really set the law out beautifully. It's sort of, if you were looking at a textbook, you couldn't do better than this. So I would recommend that. It's on my list database of cases, and I think it's the most recent one I've added. But if you do get access to that via the link that is floating about, and you click on the tab for cases added this week, you should find it at the top there, as long as you do it this week.
Will, Will, could you quickly just put that into the Zoom chat and I'll transfer it
Yes.
to the live stream? Because I think it's, yeah,
Yes, I will.
I'll check it out. I didn't see anything about that actually. Um, You're at Tiff, you're at Western Goddess, you're at Paul. Tiff, I think we need to have a rule about you not apologising for being late. It's all good. You're fine. Um, so as always, guys, we're going to start with the questions that have come in through the week that are anonymised, which there are two of, and then we'll start crunching through the live stream stuff. So I've seen there's already a question up there, which is we'll get our teeth into in a minute. Any other news from anyone? As I say, I feel like some other stuff happened this week, but I can't remember what it was relevant to housing. I mean, Angela Rayner's, I don't know, is she still in post? I haven't checked the news in the last
I
couple
think
of
so,
hours, but
yeah.
um, yeah, see what happens to that. The old housing minister. Nice story there. Um, so yeah, Shannon, you got any bits and pieces?
Mentioned it on Tuesday, so I don't know whether it's worth re-mentioning it. I think it's a different audience sometimes.
Yeah.
But the government have just launched their expression of interest for their disability advisory panel. If you Google that, it will come up. But essentially, it'll be working with the DWP on sort of disability benefits and policy and things like that. So if you've got lived experience of that, potentially worth going for that. And then there's also the government social housing panel, which I think the due date for that is only in a couple of days. But again, they work on all things sort of social housing, policy related and law related and stuff. So if you are a resident in social housing, you would be eligible to apply for that.
And I think they're both reasonably well paid positions, right? Or
I don't know. The social housing one doesn't have any figures on it. So I
okay.
don't know about that, and I think the disability one off the top of my head was 100
I think it's
a
200,
day, 200 a
200 a
day.
day. Yeah, I think so. Yeah.
Yeah.
Yeah, cool. Shannon, if you I remember one of those links was too long to put in the chat. But if the other
Yeah.
one does, then if you want to send it over, I'll stick it in there. Cool. I guess I should probably also say that I've just put out the training program from HPP for the next sort of 4 months. So yeah, plus this new course we're doing called Demonstrating Priority Needs. So have a look out for that if you want to. It's on Eventbrite. Should be on the link somewhere on the channel. So here, let me just put Will's link into the live chat. Oh, this is a long link. I don't know if I'm going to be able to do this, but let's see what happens. Well, I think we're right. Yeah, cool. Yes, that's the link to Will's website with that case listed there. So question one from the week is as follows. I'm gonna I hope I'm gonna make sense of it. I'm gonna do that. Share, you gonna share? You guys see that all right? Can't see anything now. Awesome. Yeah, okay, no, I can see stuff now. Can you see a blank screen, Shannon?
I can now see a blank screen and you've stopped freezing. Yeah.
Yeah, cool. My computer's thinking about some stuff, obviously very hard at the moment. Yeah, so question one is as follows, and I think there's like various bits and pieces that we might be able to say stuff about, and there might be some bits we can't answer here. But yeah, so priority status applicant in temporary accommodation on a 5-day turnaround temporary accommodation for almost 12 months. So I'd assume that kind of means it's like sort of like nightly let accommodation or something that's meant to be very short term. So assume that someone's about to add another question there because so far there's just something about it. So, oh wow, my computer's doing all sorts. Yeah, so 5-day turnaround temporary accommodation for almost 12 months. The agent originating council passed applicant to other council, an applicant accommodated via agent lettings, logging of faults with items in apartment outstanding for over 5 months. Reporting tool does not track when faults reported. Engineer turned up unannounced, and luckily, I'm a older male. No updates from agent. Properties above commercial lettings and an open water bill showed arrears of 20k against the commercial water supply. A company apparently is not legally able to supply domestic water. Debenture, is that a legal word I've never heard of? On company's house ignored. Fire escape route over roof is unlit, dangerous and accessed by somehow climbing out of the window, which opens onto the roof area above commercial lets at first floor level. Ombudsman complaint from start of application over 12 months ago is being collared by support network friend due to horrendous maladministration. Any comments? So the first thing I'd probably point to here is if we get to just bear me a sec, get to the LGSEO database. because there's a case which I think would be relevant here. I'm pretty sure it was Basildon. Let me just have a little look. Hold on. Oh, don't do that. So stop share, and then share that stuff. We did this for those who haven't seen this before. I know the regulars would have seen this, but this is the LGSCO decision database, which is on Will's website. I'm hoping I've uploaded this one, so I'm sure it's Basildon. Yeah, here we go. So this is the case, and then if we then take this number to the LGO website, if I copy it properly, I think this may well help us. So, whoop, hold on. I can't see my whole screen either. Sorry, guys. I need to do something to my computer because it's all over the place. Yeah, here we go. So here's back to the LGO decision thing. So again, you can kind of see where I'm going on the website here. Put the reference number in here, and we get Basildon Borough Council's decision. And the reason I'm kind of bringing this in is that it basically involved disrepair in temporary accommodation where there was like this company, which I think it's just called Company B in the decision. And kind of repairs not being responded to. Yeah, sorry, Company A, and basically, kind of ultimately what the LGSCO said was that it's the council's responsible for the state of the TA, whether or not the contracted company has done their job correctly. And in this case, they get £1,000 compensation for the kind of the distress. I think it was something to do with windows not working properly or something. So for the person who asked the question, have a look at this decision, have a read through, because I think some of the principles in it would be helpful for the question that's been asked. So that's the first thing I'd say. If I go back to it so I can remember the wording. So yeah, in terms of logging your faults and not being responded to, ultimately, I think it sounds like a complaint's already been made if the LGO's involved at some level. In terms of this last bit here, so the Ombudsman complaint from start of application over 12 months ago. So my understanding is, and I think I'm pretty sure I'm right here, the timeline to get to the LGSCO has to be within 12 months of finding out about the issue. So the fact you made an application more than 12 months ago, but you only found out about the disrepair issue 6 months ago, you would still have plenty of time to get it to the LGSCO. And then in terms of like the fire escape stuff, I do not have the foggiest about what the kind of the building regs would be and what would be necessary to make it a legal fire escape. Obviously, it's important, but I just don't know what the answer would be. I don't know if any of you guys know anything about fire escapes or kind of regs around fire escapes. Certainly doesn't sound like there's a fire door. It sounds like you've got to climb out a window, which I think in some cases can be all right, but I'm just not sure. Shannon?
Yeah, I don't know about specific regs, but I believe it falls under environmental health. So I mean, I guess we'll talk about sort of requesting a suitability review and stuff, but if you're getting like no luck with the housing department, I'd also contact environmental health just with these sort of issues as well.
Cool. Yeah. Yeah. So, and the LGSCO will cover complaints that go to environmental health as well as housing stuff. In terms of the water supply bit, I don't have any idea, unfortunately. So I don't know. I mean, yeah, I don't know. Obviously, a 20k water bill for someone in temporary accommodation, that's not correct. But quite how you unpick that, I don't know. In one sense, your first point of call should be the council, who should tell you what you need to do. But I don't know. Yeah, obviously this council is probably not very proactive, which is why the person's asking the question. So yeah, I'm not quite sure. I don't know what else. Yeah, what else we can say about this? I've got nothing else I think I can add to that. Which, yeah, I don't know if you guys have got anything else to say. If not, we will go to question 2
The
from the week.
only
Or you
other
got
thing to add, sorry, is this sounds really weird to bring it in perhaps, but approaching the local fire brigade because they're really, really helpful when it comes to like property safety and stuff. And I've had really good experiences with them, and they could potentially come round, give some form of report and say, look, these are the problems, this is why it's unsafe or whatever. And then again, I'm just thinking in terms of like strengthening the case to the local authority that obviously isn't listening, and going towards that sort of thing. Often the fire brigade is well respected, the authority and that sort of thing. So it might be worth a shot. I don't know.
Yeah, that's a really good shout. Yeah, you're absolutely right. I mean, a lot of the fire brigade's time is spent doing preventative stuff rather than sliding down poles and stuff. So yeah, that's a cool suggestion. Cool. That's the question. I say I appreciate that's not a particularly amazing answer, but I think that hopefully there'll be some stuff in that which will be helpful. And then the second question, again, I'm not 100% sure what it's saying, but let's give it a go as well. So, what if a person who has everything stripped benefit wise and you're suffering with a serious life threatening cancer, and the council who are evicting you is responsible for what happened to you to begin with? So, again, I think there needs to be some more detail here, but what we can say here is that if you're being evicted, even if it's by the council, that doesn't prevent you from making a homeless application when you become homeless. And yeah, I'm assuming there's a risk here. The council, without knowing any detail, the council might be looking to reach an intentional homeless decision, but being intentionally homeless again doesn't affect the initial duties to you. So for someone in this situation, they still need to make a homeless application and the council will still have initial duties. And someone with life-threatening cancer, without knowing anything more about it, is obviously highly likely going to be in priority needs. So yeah, I think that's all I can say about this one. I don't know if you guys have anything to add to this one or read that differently from me. No? Okay. So, oh yeah, so go on, Shannon.
Sorry, I'm in one of those moods today. Would a Care Act assessment be useful potentially for this person? Again, just like building that case, and we don't know the specific type of cancer or anything, but potentially if it's life threatening, it's going to have an impact on other aspects of your health and your life. So having a Care Act assessment might be useful just to build that sort of picture of what life's like for you, and then suitable housing going forward.
Yeah, really good point. Yes, it's certainly not going to do any harm. And a good social worker who does a good assessment actually, can lead to a lot of genuine help. So yeah, thanks, Shannon. Hold on, let me try and actually get this text here. So next question, which is we're now in the live stream. If someone is 2 months past eviction date and the discretionary housing has expired waiting to be housed, priority, should they reapply for discretionary housing or leave it? So I think my answer to that would be yes, reapply, because ultimately if you're still liable for the rent, you're going to basically be out of pocket here, even if you might only be there for like another month or so. So definitely apply for another discretionary housing payment the same way you did last time. Because it's worth money, and it's likely if you were eligible last time, I don't see why you wouldn't be eligible this time. So that would be what I'd say to that one. Again, chip in, guys, if you've got anything to add to that one. So just a question here about UC and bits and pieces. So with universal credit now resulting in increased homelessness, apparently welfare organisations, homelessness lawyers, etc., should know about the new rules and laws. Do many know? So, I mean, I guess, universal credit, as well, it's kind of led to homelessness in a number of ways over a number of years. So things like the LHA is linked to universal credit. I'm not quite sure what else might be linked in here. Obviously, benefit caps heavily linked to homelessness. So yeah, I don't quite know what the new rules are being referred to here. I've not heard any like firm announcements from the government or anything about this. So yeah, I don't know. I have anything to add to that at this point in time. Again, anyone else, feel free to chip in. Next question. So, question 5. Person is waiting for Section 204 appeal in December because of unsuitable accommodation. The person already has rent arrears and repayment plan with the landlord, but antisocial behaviour continues. I'm guessing here we're talking about antisocial behaviour from neighbours rather than the tenant acting antisocially. The police attendant, again, that person has physical mental health problems and really had enough of this behaviour. The person will completely stop paying rent, arrears. Well, the person will completely stop paying rent arrears, rent including arrears, even if a person receives Section 8 notice. The appeal at county court will still take place, right? Can rent arrears prevent a person from getting antisocial behaviour if won the appeal? So I'm going to have to defer to Will or Karis on this one because I think that's going to be up their street rather than mine and Shannon's. But I guess my first response is don't ever stop paying rent because of things which are, obviously this is, not okay. kind of having to experience that ASB, and it may well be the council should be doing more about it. But all we can say is definitely don't stop paying the rent for that reason. Ultimately, you're legally liable for it. You've signed a contract for it, and however difficult it gets, keep paying it. Because this is ultimately going to be almost certainly going to define where you end up living, basically, and having rent arrears on your file is gonna certainly reduce your options if nothing else. So that's my kind of like short answer to it. Karis, have you got any further kind of thoughts in terms of the actual question about what effect it will have on the county court, how that will work out?
So depending what the county court appeal is for, but if it's for something like priority need and looking at your medical situation, they then do look when it comes to housing you and issuing the main duty. There is a possibility if you stop paying your rent, it would be considered a deliberate act on your part. So you could be found intentionally homeless at that point. So even though you've done the county court procedure, they've got to look at it and look at your situation now and why you stop paying the rent at this point.
Yeah. Okay. Yeah. So I mean, I think I think the message is keep paying it. And I guess ASB is difficult. I mean, it sounds like this person's already reporting it to the police and stuff. So in one sense, you're doing the right thing. There will be an antisocial behaviour team at the council somewhere, and their job is supposedly to kind of deal with this sort of situation. I think at some point it may be possible to get some evidence together to actually, get the council to move this person to more suitable accommodation. But when it comes to ASB, councils obviously take the line that if they accept that that an area or kind of a particular property is suffering from serious ASB, and they move someone out, then they're going to have to move someone else back in straight away to kind of keep their voids down. So they just don't like acknowledging there's a problem. So it might be, again, if something, if you're at this stage with the solicitor already, it'll be something to discuss with the solicitor to see if there's anything else they can do to potentially try and get the person moved to a kind of more peaceful accommodation. I mean, the effect it's having on this person's health is a real consideration the council need to address, and they need to take that into account. At what point actually the council must move this person is maybe a different question. But yeah, anything to add to that one at all, Will? Will, good.
No, the only thing I'd say is that a homelessness appeal will go on, and I mean, and everyone involved in it, perhaps except the person here, will carry on and will only be focusing on that. It may be that somebody from the county, if there's been a material change, like for instance, if you got rehoused and entered into a new tenancy agreement and you were challenging a decision that you weren't in priority need for housing, somebody from the council may say, well, hang on a minute, we'll withdraw the decision you're not in priority need, but we're making you a decision that you're homeless, or may say this is a waste of time. And the judge may be a bit annoyed, say, why are you here if you've got rehoused? But in this case, it sounds like the person may still need to benefit from the homelessness appeal. And I would say, I'm sorry if you touched on this, obviously rent arrears could affect you getting social housing because a lot of allocations policies exclude people with rent arrears, don't they?
Yeah. Yeah. I mean, I don't know. I mean, there's a number of cases which went really bad for the tenant, where they kind of withheld their rent payments because of real things, but it just had there was nothing good came from it from their point of view. So yeah, as difficult as it may be, I think this person just needs to hang in there and keep paying it and wait for the appeal. But keep raising it politely with the council. Keep a log of things. Eventually, when there's enough police attendances, things will start to shift. Eventually, is probably the ultimate reality for it. But yeah, who knows how long that will be. Yeah, cool. So next question, which is another multi-parter. So let me just get the other bit as well. Under the relief duty, a family was asked to view a property as interim accommodation, but from my understanding, the council directly provides without asking if the applicant wants the property or not. Can the council refuse the accommodation until they received a letter from the council dealing with the private rental sector team? So I'm trying to. I could probably get a bit of code of guidance here up to help us out here, because certainly for like settled accommodation, the guidance is that council should allow people to view it. But I think when it comes to interim accommodation, it's just not. They probably can get away with just kind of offering you something without you seeing it at all. Let me just see if I can get the code of guidance up and see if we can find that bit just to help us out a little bit. So for those who haven't been on the stream before, this is the Homelessness Code of Guidance. It's the rule book for councils, and it is effectively legally binding. It's telling councils how to interpret the law. I think I'll have to play around with what I'm searching for. If I put view, it's going to say review lots of times. Let me go to chapter 17 because it's in there. I can't remember what other wording's in the paragraph to actually find it though. So if we start here and see what happens. I'm going to have to go. Oh, there's 279 hits here, but we're going to just go. Is that it there? No, it's not going to help us. I might need to just kind of find this whilst we continue talking. Let's go for the chapter. No, let me go back to chapter 16 for a moment. I'm sure there's a better way of doing this. Okay, no. So, okay, right. So let me go back out of this. I'm going to try and find the reference to it whilst trying to answer the question in a bit more detail. So yeah, so I don't think I think ultimately, in one sense, the textbook answer is always going to be the same, except the property, particularly since it's interim, particularly because there's not a lot of review rights you have at this point. In fact, you've got no review rights. The only way to challenge the suitability of interim accommodation is by getting a lawyer and going to court, or technically just going to court, but that's probably not really plausible for people who aren't lawyers. So I think, any kind of refusal from the of accommodation, the council will be rubbing their hands and say, great, that's the end of that duty then. And at best, you then make it very difficult to then kind of win the argument with them. So they need to, the textbook answer is to accept the accommodation, and then if it's not suitable for some reason, find a lawyer. And once the main duty is accepted, we're talking about a family here, so I'm assuming kids, they're going to be in priority needs. Let's say they're not intentionally homeless. Once the decision is made that the main duty is owed, at that point you can then challenge the suitability of accommodation through the Section 202 review process, which you don't need a lawyer for. But yeah, it's just weird kind of part of housing law that in the interim stage, you have very little kind of power to actually challenge the suitability of that type of accommodation. So yeah, anyone else want to add anything to that one?
Could I just add, I was looking at the shelter website while you were talking then, and even with final offers, shelter is a little bit uncommitted because it says councils should let you see the accommodation before you decide whether to accept it. If a viewing is not practical, the council should show you photos and answer your questions about the tenancy. Now, it is significant there that the word of choice is should rather than must.
Does it say in the footnotes there where that's from? Because that's the bit I'm after. That's that I recognise the
Yeah,
wording
and
there.
I was just looking for that as well. There is case law, and I've forgotten where it is, but that you basically, I mean, definitely with the temporary accommodation, they are allowed to say you've got to sign for it before you view it. Although it does fly in the face of common sense and humanity, doesn't it? But I think they're just worried in practical terms, if they've got three people going out to view a property and two of them accept it, they can have a fight. And it's easier just to say, well, you've got to sign for it before you see it. Um,
Yep.
but I'll try and look into that.
Yeah, if you can find the reference, as I
Yeah,
say, I'm sure it's in one of these chapters that I'm scanning through here, but I just can't find a bit. Because I think, I think it basically says, it's kind of it's best practice for a local authority to let you view properties, but
yeah,
it's not, it falls short of saying they must do. I think it does say, like, in terms of like long-term accommodation, I think it says there needs to be a good reason not to allow someone to view a property, and that might be, for example, that it's 100 miles away. Something, I didn't use that word term, but that's what it's kind of talking about. So anyway, yeah, whilst I'm going to try and find that basically whilst we continue on, and we may well circle back to that when we've kind of find the bit we're talking about. So there's some questions about benefits there which fall outside our remit really. What's going on here? Oh man, my computer's really not doing well. So I've saw the question. It's now okay. Here we go. Got it. So this is another multi-parter. Question 7. Just to say, guys, as I always do, if you ask the question in advance on any video on the channel during the week, I'll get a notification and there's no character limit. Or if there is a character limit, it's like 1,000 characters or something. So you don't have to kind of like spread your question out over multiple posts. But I think I've got it all there. So yeah, question.
Just before we read it out, sorry, you've pinned that question in the YouTube chat instead of the data protection.
Didn't mean to do that. Let me see if I can unpin it and pin the right one. Yeah, so my computer is just jumping all over the place. Let me just pin the right one. Thanks, Shannon. Yeah, cool. So question 7, a family with a relief duty letter 1 year ago where it states the council secured interim accommodation at empty space. So this is just a template letter, I guess, unwritten, and no accommodation provided saying, despite the letter saying so. Can the family complain to the LGO for this? Family had to pay the court fees. Landlord pursued the process and still facing eviction. Yeah. I mean, yeah. So this sounds like it's a very kind of straightforward case of the council not housing someone when they should have in the eviction process. So in fact, I'm going to go back to the LGSEO decision database for a moment because there's quite a lot of stuff on there about it. So because yeah, it's a very common thing. Councils basically know that they're breaking the law when they do it, I think, most of the time, but they know that they can probably get away with it. So if we just go to search for the term bailiff, and we've got all of these kind of cases here. Let's choose this one here just at random. So again, get the thing here. I'm gonna have to just do this for a second. Hold on, I can't see half my screen. There we go. Cool, here we go. So Hillingdon Council. This again is just one of many cases like this where, yeah, they've been advised to stay past the Section 21 stage, and in this case, they got £800 compensation. Quite a few of the cases like this, the people get the court costs kind of reimbursed. But yeah, this if you just kind of read a case like this through, you'll kind of get the whole kind of explanation of when at what point you become homeless in that process, when you basically should be treated and offered interim accommodation. So yeah, I'm hoping that answers that question. I need to set my screen up slightly differently so that everything doesn't block each other next week, but I'll wait till then. So yeah, anyone want to add anything to that? Does that feel like a adequate answer to the question? I guess nods. Yeah, cool. Okay, so I shouldn't laugh here. So the next question is, how long does it take for West London councils to normally answer inquiries made to them? I think the answer is how long is a piece of string? Because I'm sure loads of councils around the country, particularly London, will almost deliberately just kind of delay in getting back to anything. And that often means, to get a response, you either need to involve a councillor or you need to complain. So I think, yeah, the law is always the same in the sense that council should always basically, kind of communicate with people properly and in a timely fashion, and that certain things should happen within certain time. So, for example, the main decision should be made within a certain time, the relief duty should be accepted within a certain time, and so on. But it's kind of, it's such a common issue. I think, it's just difficult to say, really. I think all you can do is complain. And I mean, potentially involving a councillor might be quicker because the council will basically go to the housing team and say, "Can you respond to my constituent, please?" And you might then get a response out of it. Might be a related question here as well. Oh yeah, no, I think that's the same question effectively. I can't see the difference between those questions. Okay, given that my screen's going all over the place, I think I have got all the questions that have been asked. There's some other kind of comments there which are yeah, kind of leave within the conversation. But yeah, I think that's it. And there is another question. Hold on. An individual applicant dealing with domestic abuse currently in temporary accommodation in the same council of the perpetrator chose to make a new application to a council outside of London. Is that asking can they? It depends what stage the application is at. If the person's still in interim accommodation, then yes, they could technically withdraw their application and make a fresh application elsewhere. But doing that is risky in the sense that the kind of confusion around it could cause some problems. So if you wanted to do that, you'd want to speak with your housing officer in Council A and say, look, I want to apply somewhere else. I want to withdraw my homeless application. What are the implications of that? And get their written advice, because what you don't want to do is for there to be some kind of problem and then they kind of say, well, you've given up accommodation and you made yourself intentionally homeless. So yeah, it kind of depends what stage you're at. If you're in temporary accommodation after a main duty's been accepted, the answer will be different. And in one sense, I think you would be stuck with Council A. Now, Council A would still have a duty to provide you with safe accommodation, which may well be outside the district. But in one sense, it could be anywhere. So as a general rule for survivors of domestic abuse, you want to apply to the council where you want to live as, kind of positively. Even then, it doesn't actually guarantee it, but rather than kind of approaching a different council and wanting to be housed in that area, housed somewhere else, it just gets very difficult. So yeah, I'm not sure if there's more questions coming, but now would be a good time, guys, to put your last questions in, because I think we're going to be kind of wrapping things up very soon. I'll give it another sort of 30 seconds or so. As I say, I think I've covered all the questions that have come. I was going back and having another look. Yeah, I think I have. So yeah, which case we'll call it quits for tonight. It sounds like Will and Karis are absolutely battered by the caseload at the moment in terms of just the amount of work they've got on. So I don't think Will's going to be doing his live stream this Monday. Well, there's some more stuff coming. Let me see what's going on. Okay, now we have got a question. Okay. So question 10. So A makes a homeless application in January 25 and receives a poor non-priority decision, which they request a Section 202 review of. Local authority withdraws the Section 184 decision and says the original housing officer will be in touch with additional questions. That sounds like a bit of BS there, to be honest. Although actually sometimes it can be in your interest to kind of allow that to happen. So if by withdrawing the initial Section 184 decision, they're essentially accepting it was flawed, then hopefully you're going to get a better decision the next time. But I don't think they should be doing that. They should basically go through the Section 202 process with it. I don't know if that's something you guys have seen in the world of soliciting, Will and Karis, and have anything else to say about that. But yeah, I think ultimately there's already a complaint here in terms of the time scale that they've taken to make a decision. They should have made it way before this.
There's more to it.
Oh, is there? Okay. Oh, okay. Yeah, there's some skullduggery going on here.
Yeah, sorry.
Yeah. A week goes by and nothing from housing officer. Call to chase up regarding Section 108 accommodation and told the homeless application was made that day, not January. So that is going to need either a rational conversation with the housing options manager or a complaint. That's just I don't even know. That's probably more incompetency than kind of like malevolence, so to speak. But that's not right. Basically, you can't just withdraw a Section 184 decision presumably because it's flawed. You need to roll with it, really. So yeah. Oh yeah, there's even more to it. Hold on. Yeah, I think my answer is still the same, that you need to make a complaint, unfortunately. Then says that A cannot contact them for 24 hours to then request Section 108 accommodation, instructs to call out of hours to be placed for one night only. That is, that's just kind of like, it's not unheard of to have that sort of thing happen at councils, but that is just literally just complete incompetence and lack of communication between teams, and probably a lack of suitable oversight of the frontline officers, because I think any competent sort of manager would kind of not be pushing for that for whatever's happened there. Basically, that just sounds like a mess. And I think my answer is still the same. Try and find a manager to have a rational conversation with, or just make a complaint. And ultimately, yeah, the paper, yeah, the paperwork doesn't lie. The application can be proved to have been made in January 25, and whatever else happened afterwards just doesn't. It just seems like a mess. I guess making a subject access request would probably also help untangle some of it, because presumably at least some of this will be on the applicant's file. So yeah. Have you guys got anything to add to that?
Well, I've been a bit quiet, so I'll say something. I think that the question here does illustrate one of the problems is the massive power imbalance between the applicant and the council staff. If they can tell you anything they like, really, within reason, and the problem is, what can you do about it? And if they tell you you can't call up for 24 hours, which is what I meant, which is nonsense, it just makes me feel very fortunate that when I deal with councils, and it goes to Mo's question, how do you ask them a question? Or the other question, how long will it take them to answer? I mean, they may just not bother to answer and see if you make a fuss. But with these other ones, you've really got to just keep pressing away. And I mean, I mean, it could just be that what you get here is it could just be that after they've got a new housing officer assigned to this case after they basically withdraw the decision on review and then they send it back. Now, let's suppose a new housing officer got it because the old one had left, and they may think it's a new application that was only just made. So when they say that, they may be mistaken. But the problem is they aren't really into they're not very self-aware. So if you said to them, no, it wasn't, they think you're just picking a fight. So I would say just don't underestimate how much they'll mess you around, and try and get somebody to help you challenge them. Could I just say one thing? You remember we've talked about a common mantra from social workers when people go to try and get help from them, particularly in relation to housing matters, is to tell people there's nothing we can do. We can take your children into care if that's, and would you like us to do that? Now, people will say, oh no, they don't do that. And social workers would say, no, we never do that. But I mean, Mike, you know from that video you made, which I always go on about, there was a poor woman who went to, I think she went to how many councils? She went to 2 or 3 different councils, and they were social workers all told her the same thing. But I had a variation on that in a case in the last couple of weeks where not only they didn't just say we'll take your children into care, the mother was worried about what would happen if her landlord, who was threatening to evict the family, did evict them and put them on the street. And she said, can I come to the council with the children if we get evicted? And she was told, no, you can't. And if you do that, we'll call the police to take your children away. Which obviously was a horrible thing to do and really scared her at a time when she was already in a really bad place. And of course, she wrote to the MP about that, but there was, howls of indignation from social services. We would never do that, but you could sort of tell from the language that they sort of knew they had.
I'm pretty sure Shelter or Crisis campaigned on that issue a few years ago about that kind of advice. So they were basing it on quite a bit of evidence, I think, in terms of how prevalent it was. So yeah, and it's not just, I've seen it in multiple cases before, one of which got upheld by the LGO actually. So yeah, it definitely does happen, but I think it kind of touches on a number of other things that happens quite regularly that they would deny strenuously if they were asked, but kind of everyone knows it happens. So Tiff, yeah, just to say, I know you're talking about housing benefit there, but it's not really a question we can answer. I don't know whether the housing benefit manager will be lying or not. They might just not know what they're talking about, basically. So, and then just another question, just a reiteration on this one about time limits. Yeah, just to kind of reframe. So we're back to question 8. There are certain kind of certain time frames which are set legally, but when it comes to just kind of corresponding and kind of, communicating properly, there's not really kind of set time limits other than just to say it has to happen in a timely fashion. So it is something you see getting upheld by the LGFCO because they'll say, that there'll be a component of the compensation because the council delayed making responses, didn't respond at all that kind of stuff. And it can, it can kind of stretch into a few £100s. But unfortunately, I guess it's yet another kind of shortfall of the law in that although the law itself is good, there's not really much penalty or much incentive for council to sort of follow it. They probably know a lot of the time they'll know what they're doing when they don't resource their frontline staff properly. They know that by not resourcing them and by not picking up emails when they should, they'll actually be saving the council money because people will be left homeless rather than being housed. So it's deliberate, but it might not be the housing officer you're dealing with. It might be they're actually trying their best, and they just haven't had the resources through from their kind of from the politicians in the area to actually make sure it can all work. So yeah.
There's another question from that person saying about how do you ask a question to the council? Which actually is like a really valid question. Like, is there a page on the council's website? But how do you?
Oh yeah.
To the council.
Oh, I see. Yeah. Okay. So yeah. I'll put this all together because it's all linked, isn't it? So yeah. So I guess it depends. Like what your question. I know it sounds. I'm not trying to be facetious. What your question's about, because obviously, like if it's about your case and you've had correspondence with a housing officer already, then you want to be emailing the housing officer directly, or if you can find out who the manager is, kind of sending emails to the manager. If you want to ask a kind of a question politically to the council in terms of in a housing committee or something, then yeah, there'll be pages on the website which kind of explain when the next committees are, and there'll be at least some information about who you need to send the question to. So, but they won't take questions about individual cases. So if you kind of went to a housing committee and tried to get your situation sorted out there, they wouldn't allow that. Would kind of fall outside the remit of the meeting. I mean, what you could say is, yeah, what are the council's waiting times, or what's the policy about councils responding, housing officers responding to inquiries? That would be a question you can ask, but you couldn't say about my case, because that would, as I say, that's specifically not allowed within those settings. So I don't know if I've got the right end of the stick with that question, but that would be my answer.
They've just said question regarding waiting times, so that would be like
Okay. FOI. So yeah, in terms of average waiting times, you can FOI it, which there will be a page on the website which is like freedom of information. This is how you do it. But some councils publish it anyway. Now, there's no harm in making an FOI request because worst case scenario, they'll just say it's on the page here, so they're not going to, not going to tell you off for it. But you might be able to dig out the. I mean, I remember like it was either Lambeth or Lewisham or one of those kind of central London council or South London councils. They already published that stuff. Kind of
waiting times around communication.
Oh, okay. Sorry. Yeah, no.
I think that's what they're on about because the rest of it is all about.
Yeah, they won't be I'll be very surprised if there's a policy that says housing officers must respond to all questions within a set time frame because it just sets them up to fail. But you probably will have stuff within the council's policies that says communication should be timely, but that doesn't really mean anything. It's not until you kind of get it to the LGO that I think you're going to be able to get anywhere with that sort of issue. Yeah.
Can I just say a quick word on communication? I find that local authorities are very, very bad at responding. So, without repeating myself, I would say about 1 in 3 inquiries may be completely ignored. Even if you wrote to them and said, "Can you accept a homeless application from this person?" you might not hear anything. So, I have an approach where I send an initial email. And to the answer to that question before, yes, always try and use email, but good luck trying to get the email because they hide those emails really carefully. If you look on most homeless or housing department websites, there won't be an email message, but an email address to contact the housing department. There'll be maybe a form which you can fill in online. And you might get a reply from an email address which you can then use, but they don't like giving out emails. But send an email. If you don't get a response, I think 7 days, depending on how urgent it is. Obviously, if you're on the street, then 24 hours is too long. but allow 7 days. And then I send a polite reminder, say I haven't had a response, it's been 7 days. And then after 14 days, I send a standard one with the same thing, but a paragraph saying if I don't get a response in another 7 days, I'm going to make a formal complaint. And that paragraph's in bold. And I usually put my telephone number under there, so please call me if you want to discuss this. But then I will make a complaint if I don't get a response. And you can either do that by writing a formal complaint to the person you've been writing to, but they may just ignore that. But most councils, if you go to their website and type in complaints, they do have a system, and it may be another form, unfortunately, but there is that is a way of getting a response. So I would say if you haven't had a response, that would allow for 28 days, wouldn't it? That you should be making a complaint, because there's absolutely no excuse for even routine correspondence not being answered in that length of time.
Yeah, I mean, I think you're very polite, Will. I mean, my old colleague John at Just Us, he would give him like, yeah, if he didn't get a response within a few hours, he would then start just sending it up the chain, like in terms of the hierarchy. Now he obviously got to know the hierarchy, he got to know who everyone was and who their email addresses were. But I think I'd maybe go back to kind of involving the counsellor and just approaching the counsellor, explaining that you're trying to get some important information out of the council, you're not getting a response, and just keep chasing them, keep hounding them politely until they kind of lean on the housing team to actually respond to it.
Sometimes if you bug customer services instead of the housing department as well, that will like go further up the chain, and customer services basically get really annoyed, and then it will trigger the housing officer doing something. So going to customer services and repeatedly being asked to be put through or to get in reply or whatever, or again emailing customer services, because I think there's a question there around should communication by a housing officer be by email? The client officers only wants to do phone calls, and I think personally I'd recommend to do things via writing an email.
That's a proper red flag.
Yeah, it's a massive red flag, and like particularly if anyone's English is like not great, having stuff in writing means you can refer back to it, and like we forget that this is a legal process, so things should be in writing. Yeah, I don't think if housing officer can force someone to do phone calls, absolutely not. Particularly if there's like
Definitely
sensitive
not.
topics being discussed, you know what I mean? You might not be in a private place, you might be in public, and you're having to spill your guts about why you need help with housing and everything else. It's inappropriate most of the time.
Yeah. And I mean, sometimes it's in your interest to have a face-to-face. So I had a face-to-face with a client and the housing team on Wednesday, but I followed it up with a very long email, which kind of had 8 points of what had been said. And I kind of said to, have I got the right end of the stick here? And they got back to me and said, yeah, that's all right. So yeah. Yeah, good luck, Martin, by the way. Just I hope that goes right. There is, yeah, I mean, yeah. In terms of this kind of idea of like asking for information from a council, you can do it, but you need to kind of work out how best to kind of phrase it. So there's a question here. No, not that one. That's the same one as before. But this kind of idea of, can you FOI the number of times councils lose paperwork? What's going on here? It's all going wrong. Let's get this into color we can actually see. So yeah, if you ask that question to a council, how many times have you lost initial letters, then they're going to come back and say we don't keep that data and we've got no way of getting it. But you might be clever and you might be able to find a way of like saying, how many complaints are about lost paperwork. That would be something they should be able to obtain and provide. And we got a question about complaints at Bedford at the moment, and the actual response Shannon got back was to say we're not going to provide this information because we're going to publish it anyway in like a few weeks' time. So you have to wait and hang on till then. So yeah, cool. I think that's all of the questions, guys. We'll call it a night. We'll be back next Thursday for sure, doing more Q&A. We may or may not be back on Tuesday with the kind of the off-piste live stream. But yeah, there's kind of I'm sorry for the questions, been a bit bitty tonight, and kind of me not really keeping track of them all. But hopefully there's some helpful stuff in there. Yeah, hopefully it'll make a difference to people listening, really. So yeah, we'll see you next week.
Bye.